If UNCLOS is an old guard, I don't know what that makes me. When I turned 30, nobody was questioning my relevance. From Australia's point of view, UNCLOS remains as relevant today as it was the day that it was agreed under the auspices of ASEAN. It remains the constitution of the seas, and the main challenge for most of the countries involved in UNCLOS is its effective implementation and enforcement. The other problem I have with this panel is that you will see that we are all gentlemen here. This is, I think, the second or third year in a row when I've moderated a panel exclusively made up of men. I don't think I'll be able to accept any more invitations to moderate panels like this, to be perfectly honest. Australia did nominate several highly qualified women to participate in this panel, but unfortunately, we are where we are. But maybe that next year we can do better. The panelists today are Mr. Andrew Murdoch, Legal Director of the Foreign, Commonwealth and Development Office, Dr. Mohammed Taufan, who's a legal and diplomatic official from Kemlu, Dr. Takei Yoshinbuno, who is a professor of international law at Keio University, and my friend Dr. Nguyen Zang Tang, who has just been appointed as Director General of the Legal Office in the Ministry of Foreign Affairs in Vietnam. And most recently, he had the honor of being Vietnam's Consul General in Sydney, which I think is a great job. Thank you, gentlemen, for being here today. All the speakers' biographies are in your packs, so I won't spend any more time in describing their eminent qualifications. I will instead start with Mr. Andrew Murdoch and to invite him to make his remarks. The floor is yours, sir.
Thanks very much for the introduction, and I do agree with your remarks on gender balance. Kicking off today's panel, we haven't actually massively coordinated, so let's hope we do a bit of not too much duplication. So in 2022, the UK's House of Lords International Relations and Defence Committee published its report into whether UNCLOS remains fit for purpose. I would commend that report to you. The committee heard from lots of witnesses. I had the honour to give some evidence on behalf of the government at the time. And they heard much praise for its framework nature. But as we know, with limited appetite to renegotiate the convention, how well does it respond to new challenges and concerns? The committee's view, in summary, was that if UNCLOS is not supplemented, nor its provisions further developed, it will no longer be fit for purpose. My proposition, and I think actually hearing the excellent presentation from the judge, is a very similar vein, that in fact the convention is indeed relevant, and it is a living instrument capable of being both supplemented and developed to respond to emerging challenges. So I want to illustrate that in 4 areas. The first is, we touched upon this very briefly in the last presentation, the ability of states to come together to agree new implementing agreements under the convention. The latest and third implementing agreement is, as we've heard, the BBNJ Convention, which opened for signature in September last year, and the UK was hot off the press in terms of doing that on day 1 in New York. And while the negotiations took well over a decade, and for those in the UN basement in the last session, where the last marathon 36+ hours felt like a decade even in of itself, it was done, and it was adopted by consensus in a very difficult geopolitical environment. Although we had some wobbles near the end, they didn't quite materialize, and there was no vote was called. So the convention can, albeit with some difficulty, be supplemented to deal with new challenges. But it is a framework treaty, and as we know, the Convention provides the ability for competent organisations to develop rules and standards that supplement and provide the detail for the Convention on many technical issues. And the IMO is absolutely at the top of its game on this, with SOLAS, MARPOL and others, a huge myriad of provisions which can do exactly that. And I know in session 6 we'll be hearing a little bit more on maritime autonomous surface ships and some of the work of the IMO and others on that area. But in addition to this, how can the Convention deal with and accommodate with broader issues of concern? And this brings me to my second issue, which is climate change. We know in the resolution of the 6th of December 1988, the UN General Assembly recognised for the very first time that climate change is a common concern of mankind. In the same resolution, it stated that the emerging evidence indicates that continued growth in atmospheric concentration of greenhouse gases could produce global warming with an eventual rise in sea levels. And the IPCC has reported that the ocean is a fundamental climate regulator on seasonal to millennial timescales. And we've heard the judge mention again the great work of the tribunal in its advisory opinion in response to the request by COSIS, a very small organisation, putting its request in there for answering questions on the specific obligations of the states parties under the Convention. And in broad terms, those obligations concern pollution, protection and preservation of the marine environment from climate change. And we saw in the 2024 opinion a very clear illustration of how the Convention to have regard to international and agreements and other instruments to address this nature adopted after its existence. And for example, it did this even in the absence of terms that were in the question itself, including climate change, greenhouse gas emissions, ocean acidification, not mentioned once in the Convention, but the Convention was able to grapple with those issues, and as we've heard, for example, recognise that anthropogenic greenhouse gas emissions form part of pollution within Article 1. The fact the UNFCCC and Paris agreements are relevant to the interpretation and application of the Convention with respect to marine pollution from greenhouse gas emissions, and that the temperature goal and the timeline for the emissions pathways set out in the Paris Agreement informs the content of the necessary measures to take under Article 194. The tribunal did not address my third topic, which is one of sea level rise. Now, as we know, sea level rise is a global concern. Coastlines are likely to regress. Some maritime features will change status. Some may disappear completely. The legal and political question is whether this will mean baselines and other outer limits of maritime zone also move inwards and maritime entitlements reduce. This is an important area for all coastal states, particularly small island states, whose maritime entitlements are particularly significant for their identity, culture, and economies. But it's not just them. So when the Convention was drafted, significant sea level rise as a result of climate change was not within the contemplation of those negotiating it, the drafters. No express provision was negotiated to address this scenario, even negotiated and rejected. It just wasn't dealt with. The Convention arguably adopted an assumption that coastlines and coastal features were, with some exceptions, likely to be largely stable. Now, in response to this, a number of states have sought to find a solution. Their approach, commendably, is one that is trying to find an approach that falls within the grain of the Convention itself. In August 2021, the Pacific Island Forum, PIF, made a declaration to the effect that its members intended to maintain their maritime zones without reduction. Essentially, they said they would not review or update their baselines or outer limits of their maritime zones as a consequence of climate change-related sea level rise. The Association of Small Island States made a similar declaration in their Leaders' Declaration of September 2021. The announcements, in terms of a kind of legal explanation, were broadly on the basis that the convention itself imposes no affirmative obligation for states to keep their baselines in accordance, their baselines of the outer limits of their maritime zones that derive from them under review, no express provision, or to update them once they've been established in accordance with the convention. And it therefore follows, the argument goes, that if a state has established its maritime zones in accordance with the convention, it is permitted to maintain those boundaries, all those zones and rights that flow from them, notwithstanding changes to the coastline as a result of sea level rise caused by climate change. Now, we know there's a lot of discussion, including with the International Law Commission, on these areas. There is no consensus on states yet. We may well see in the future interpretive declarations if there's enough momentum behind such an approach of states. But it's importantly that the approach from PIF and others that are articulating this has two key considerations. The first one is that the convention supersedes any incompatible pre-existing rights or customary international law. A response to sea level rise based on historic rights would be contrary to that approach. This picks up on the comment in the South China Seas case in terms of why issues like historical title in the South China Sea would be rejected for the same logical reason. Secondly, it does not alter the requirement that for states to establish these zones and preserve them, they have to be lawful in the first place. So no basis to freeze excessive zones. My fourth and last example is how the convention deals with developments in technology. There are lots of examples, I'm going to give one. The MV Arctic Sunrise case involving the Netherlands and the Russian Federation, I won't go into details of it, but it did look at one area of what the meaning of hot pursuit was. UNCLOS requires in its terms that pursuit may only be commenced after a visual or auditory signal to stop at a distance which enables it to be seen or heard by the foreign ship. On a strict interpretation of this provision, the use of a radio signal, UHF radio, would not be permitted because it wouldn't be the strict requirements. The ILC, when it looked at these on an earlier draft, took the view that that would not be permissible. The arbitral tribunal, much to its credit, took a different path. They took the view that given the large areas that must now be policed under the convention, going out to 200 odd miles, and the availability of reliable advanced technology, sensors, satellite, etc., it would not make sense, their words, to limit valid orders to stop to those given by an enforcement class within the proximity required by radio. This amounts essentially to an evolutionary interpretive approach, and one that you could see being adapted in other areas. Very much one that didn't tend to move away from the definition text, but one that came to update and relevant to state practice. So those four examples in conclusion, my time's up, yes, is a very clear answer to yes, there is an answer to the Lord's question that very much the convention is capable of being supplemented and certainly remains fit for purpose. Thank you.
Thank you, Mr. Murdoch. 10 minutes goes so fast. The next speaker is Dr. Muhammad Taufan from the Indonesian Ministry of Foreign Affairs. Dr. Taufan, the floor is yours.
Thank you very much, Ambassador Andrew. So, very good morning, distinguished delegates. Indeed, it's my privilege to appear before you to discuss this issue and share the stage with the distinguished panelists. And this morning, I'd like to discuss about the Indonesia's perspective or approach on how to promote UNCLOS itself. And I would like to divide my presentation into four big ideas. First, about the Indonesia and UNCLOS itself. The second one about the application of UNCLOS in the different level. I'd like also to highlight ASEAN and Indo-Pacific. And last but not least, I'd like to address the recent or emerging issues that we face now. Next slide, please. So before I continue, allow me to extend my thank you to the organizer, the DAV, for the invitation. So there are 2 points that I'd like to highlight in this slide. First, in 1957, I believe most of us aware that Indonesia initiated the Juanda Declaration that several years before the first and the second conference on the law of the sea. We also promulgate law number 4, year 1960, to transform the open seas among our thousands of islands within the Indonesian territory into the our Indonesian territory. We call it as a unity factor instead of the separate cause among our territory. So Indonesia and other like-minded countries successfully incorporated the archipelagic legal regime into the UNCLOS, more specifically under Part 4. And then I would like also to mention that throughout the history and based on the statements made by Indonesian delegation, high-rank officials during bilateral, regional, and multilateral forums pertaining to the law of the sea, Indonesia perceived that UNCLOS remained pertinent to guide states and relevant actors or organizations. It certainly and obviously contained rights and obligations, for instance, on the maritime zones and etc., as well as the UNCLOS shall remain relevant to provide principles and legal basis to address emerging issues. This is what we'd like to discuss in the later stage of these presentations. And I'd like also to underline that UNCLOS cannot implement it only through, let's say, the individual state or the individual state approach. The cooperation is needed. And if we take a look the content of the UNCLOS itself, the cooperation actually is not really many reference within the convention. That's why Indonesia's foreign policy highlight the importance of the cooperation, and we believe this is an effective tool or avenue to promote UNCLOS. I just want to take a look deeper. If in the UNCLOS there are only several terms of cooperation. We know that at the time during the conference, perhaps the heavy would be the legal approach, but in fact we know that during or throughout the practices, the cooperation is the fundamental elements. That's why there are only several terms of cooperation, for instance, in the Article 43 or mainly in the Part 12. But again, Indonesia's foreign policy believe that the cooperation is one of the effective tools to reinforce the implementation of UNCLOS. Now, I'd like to address 2 major points of the application of UNCLOS on the national and bilateral level. I'd like to address the regional and global in the later stage. On the national itself, Indonesia already promulgated many of the laws, decrees, and declaration which in line and compatible with UNCLOS. I can say a few of them, for instance, law number 6, year 1996 about the Indonesian waters, but more specifically we have government regulation on the base points, as well as the government regulation number 37, year 2002, regarding the Indonesian archipelagic sea lanes. This is what we interpret and translate from UNCLOS into the national or domestic legislation. So this is our concrete effort and attempt to not only speak or bring UNCLOS to the forum or the meeting, but we translate it into the legislation, and importantly, we practice it on the ground. We already have the 3 archipelagic sea lanes where our assets or vessels, this is a vast area, so it's not easy to monitor and make sure that all foreign ships, for instance, follow the rules, national and the international rules. And on the bilateral one, I'm happy to say that for instance, on the maritime cooperation, we have numerous memorandum of understanding which refer to UNCLOS as the basis of the cooperation. And then on the practice of maritime boundary negotiations, we pleased to see in the last 3 years, we have concluded the agreement with Vietnam as well as Malaysia back in 2022 and 2023 respectively. Now we are in the middle of domestic process or procedures, which it takes time because we are in the middle of the transition of the new administration. And now I'd like to move to the regional fora, where yesterday we have quite much discussion about this from Pak Arto to Professor Dewi Fortunananwar and other distinguished delegates. So I just want to add two points that in the ASEAN we have clear modalities, for instance, the ASEAN Regional Forum, the ASEAN Maritime Forum, and other mechanisms that can lead to the reinforce, deepen our understanding and capacity of the ASEAN member states as well as its counterparts. And then the recent development in 2023, we have the ASEAN Maritime Outlook, where it compiled all cooperation. So we keen to avoid the redundancy and identify what are the cooperation that need to pursue. And in the Indo-Pacific itself, I think we also discussed this yesterday, but I'd like to add that the ASEAN Outlook on Indo-Pacific also put UNCLOS as one of the main references. In 2023, Indonesia initiated the ASEAN Indo-Pacific Forum, which focuses on the economic sector. This is the beginning where we also believe, at least personally, that the cooperation on the political and security also very relevant. So we are not shy away on this issue, like what my DG yesterday mentioned, that both economic as well as other like security sector also pertinent to address during the ASEAN or Indo-Pacific Forum. These 2 points that I'd like to mention, but I also believe that many of you are quite curious about the issue of South China Sea and what Indonesia views on this matter. I think Indonesia have a very crystal clear view during the interaction and behavior that Indonesia is not the claimant of the claim over the features in the South China Sea. As well as Indonesia would like to refer to the UNCLOS and then already sent its diplomatic notes back in 2010, as well as in 2020 to the UN Secretary General with respect to this issue. And the last slide that I'd like to discuss, I know the time is very limited. This is we now face, like Mr. Andrew discussed, that many emerging pressing issues now. Allow me to take 2 examples here on the issue of seabed mining exploitation. For instance, in the ISA, we face the quite sharp differences among states. And Indonesia believes that the balance between the interests of developing states, for instance, as well as the interest to ensure the marine environment protection is the interest that equally important. That's why we believe this approach should be the priority, become the major factor for states to decide. And don't forget also how the international law, particularly UNCLOS, still put this regulation within this, inside the convention itself. And about the BBNG, I believe Indonesia, like many other countries now, we are in the preparation to prepare the implementation. And as for the sea level rise, we are now face the legal lacuna of international law, but our foreign minister back in September during the high-level meeting highlight that despite the existence of the legal lacuna is not prevent us to promote the cooperation to address this issue. And as for the challenges or strategies that we believe can apply to Indonesia as well as other countries, as for the strategies, we need to have effective and efficient international as well as national coordination. Deepen the understanding and collaboration is a must to get the proper interpretation as well as the consistent practices on the ground. I leave it there, and thank you very much. I will return to the moderator. Thank you so much.
Terima kasih, Pak. Our next speaker is Professor Yoshin Obu from Keio University. Professor, you have the floor, sir.
Thank you very much. Okay. Good morning, and Excellencies, distinguished guests, ladies and gentlemen. Let me start by thanking the DAV for inviting me to participate in this important conference. This session is particularly timely given the 30th anniversary of the entry into force of the United Nations Convention on the Law of the Sea, UNCLOS, this year. It is indeed an opportune moment to take stock of the achievements of UNCLOS and consider how we can proceed to address new and emerging challenges. In line with the theme of this session, my intervention today deals with UNCLOS implementation agreements and whether we should consider developing new ones to address emerging issues under UNCLOS. But before I start, I must confess quite a few issues that I wanted to address have already been ably addressed by Judge Horinochi and Mr. Maddox, so perhaps I might skip some of the lines I wanted to say. Okay. Let me start by looking at the 3 implementation agreements. The first one, obviously, is the Part 11 agreement concluded in 1994. And indeed, this agreement was negotiated to break a deadlock created by the dissatisfaction of the industrialized states with Part 11 of UNCLOS on deep seabed mining. Despite its name, and as Judge Horinochi mentioned, it is widely believed that the agreement resulted in the de facto amendment of UNCLOS. The agreement played a critical role in ensuring universal participation by all range of states, while avoiding the difficulty of actually formally amending UNCLOS. However, I should stress that the other 2 agreements are very different in context and also in nature. The second implementation agreement, the UN Feedstocks Agreement, was adopted in 1995 to address the issue of conservation and sustainable use of struggling and highly migratory fish stocks. This issue was left at the conclusion of the 3rd UN Conference on the Law of the Sea in 1982. Rather than amending UNCLOS, the agreement has successfully given effect to the relevant provisions of UNCLOS, which remain general and call for international cooperation for effective implementation. The 3rd implementation agreement, the so-called BBNJ agreement, was adopted last year following the almost 20 years of discussion at the United Nations. The BBNJ agreement addresses the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. If you look at UNCLOS, you would not even find the word biodiversity or marine biological diversity in its text, which in a sense tells that the flexibility and capability of UNCLOS allows parties and non-parties to work together to address new and emerging challenges. I should also add that there were initially, at least, very diverse views from both developed and developing states. But as mentioned earlier, the agreement succeeded in achieving consensus dealing with very diverse, different, difficult issues. If you compare these three agreements, it's obvious that they have both commonalities and differences. Given the time limited for my presentation, I will not go into these details, but suffice it to say that the two implementation agreements adopted after the entry into force of UNCLOS demonstrate that UNCLOS provides a sound basis on which we could work to implement and develop the existing international legal framework rather than amending it. Now, let us move to the second part of my presentation. I'm going to address some of the emerging issues related to UNCLOS and the South China Sea. Especially, I chose the impact of sea level rise and the security threats to submarine cables. The first issue is sea level rise. As we all know, this issue has attracted an increasing attention by the international community recently. Among other issues, the possible shift of baselines and the outer limits of maritime zones is critically important to small and developing states and other low-lying coastal states. In the context of the South China Sea, obviously, we have a lot of maritime features which are either low tide elevations or which are not entitled to generating the exclusive economic zone or the continental shelf, according to UNCLOS. In response to the actions initiated by the Pacific states, a number of states have recently gradually shifted to the position to recognize the freezing of maritime zones despite the coastal regression due to the sea level rise. While support is growing, there is uncertainty about how this could be achieved from the legal point of view, both substantively and procedurally. On the procedural point, there are a number of proposals for the recognition of the maintenance of maritime zones. For example, in the context of the International Law Commission discussion on the final outcome of the work of a study group on sea level rise in relation to international law, there were suggestions to, for example, draft framework convention on related issues. Furthermore, the UN General Assembly just had a high-level meeting on sea level rise this year, where a proposal was made to achieve a negotiated UN General Assembly declaration on the topic in 2026. Well, obviously, it is still to be seen how these initiatives may unfold in the next few years, including whether or not states want to develop an additional instrument. But if they wish to do so, then it's important to consider how they should combine issues such as baselines and other related issues, for example, the protection of persons or the statehood issues. The second issue we now turn to is the security threats to submarine cables. Yesterday, Dr. Laxmana and others have already illustrated the importance of international submarine cables for world economy and existing challenges facing these cables, such as natural disasters, accidents resulting from human activities, intentional damage, as well as excessive permit requirements. In addition to the risks already mentioned by these presentations and comments, I should also add cybersecurity issues, such as hacking and surveillance of submarine cables as another type of threat that calls for future actions. The international the international legal framework already exists in UNCLOS, dating back to the 1884 convention. However, its insufficient implementation has revealed weaknesses as well. There have been a number of actions taken for the improvement of cable security, including the establishment of a new maritime center at NATO and bilateral and multilateral arrangements. The last one, I believe, was launched in September this year by about 20 states from North America, Asia, and the Pacific in the context of in the margins of the GA High-Level Week. We still need to see if these efforts are sufficient, but if not, we might consider developing the existing framework and the convention as we did, where in fact there have been suggestions to create a new treaty on this issue. As I understood, there is no such discussion at the intergovernmental level, but if there is any major incident, I should say perhaps there might be an appetite for doing that, which I don't hope though. Well, in doing so, I think it's important to recognize that there is no competent international organization for submarine cables like the ones, for example, IMO for shipping or FAO for fisheries issues. In conclusion, as we celebrate the anniversary of UNCLOS this year, we acknowledge that there exist various challenges. However, we are fortunate to have UNCLOS, which can serve as a basis to address these challenges for the years to come, as we did in the past through the adoption of implementation agreements and other actions. Thank you very much for your attention.
Arigatou gozaimasu, Professor. The fourth and final speaker for this panel is my friend, Dr. Tang, who has to forget all about Sydney and think about the East Sea. Dr. Tang, your remarks, please.
Thank you, Excellencies. As you already introduced my new position, I should start by saying that this is my personal view only, and that does not represent any views of the organizer, nor the views of the Vietnamese government. And I also would like to thank the organizers for inviting me and giving me the opportunity to speak at this important conference. It's always a pleasure to speak at this important forum. And I'm very happy to speak under this topic. I don't know what is the motive of the organizer when, making this session under the title "Oh God," whether it is a Netflix movie released in 2020 or whether it's the new one that we also have a Vietnamese actor in that movie, and how it's relevant to the discussion here. I think that it's up to the audience to decide. But my question is that, and I think about when you talk about UNCLOS, about the relevance of UNCLOS, and also in this context, I'm intrigued by the statement in UNGA that UNCLOS set out the legal framework within which all activities in oceans and seas must be carried out. And that statement also has now become the ASEAN parlance, at least back in 2018. So, and the second issue that comes to my mind is how old is UNCLOS? We talk about the 30 years of entry into force of UNCLOS, or we talk about the adoption of UNCLOS in 1982. But my personal view is that we can talk about UNCLOS since the start of the negotiation of UNCLOS in 1973. And even with that, I don't think that UNCLOS is old enough. It is only in the middle age, like slightly more than 40 years or in like 50 years. But, every treaty is, liable to be outdated with the passage of time. And whether the past 40, 50 years is enough for UNCLOS to be outdated. And I think that my previous speakers all proved that it's still very relevant. And I think that I can stop here because they already speak what I'm going to speak. I just want to, to add and some furthers about the point first raised by Mr. Murdoch about the implementation, and also by Dr. Yoshinoki about the implementation agreement. I think that the implementation agreements do strengthen the regime UNCLOS. We do recognize that the approach adopted by UNCLOS by dividing the ocean into different areas, into different functional zones, are not adequate to address the cost-cutting issues, address the biological concerns, address the development in terms of technology, in terms of scientific knowledge. But we have other mechanisms to address that one within the unified framework provided by UNCLOS. And also, I think that UNCLOS, as I said, was negotiated like 30 years ago, 50 years ago. And at that time, we do not have enough knowledge about the oceans, about what's going on under the oceans. And that's why we need to have the implementation agreements. And I also like to echo what Mr. Murdoch said about the advisory opinion of International Tribunal for the Law of the Sea. I think that it is very interesting. I think that it is the first time maybe judge can correct me if I'm wrong, but this is the first time that it lost. Talk about UNCLOS as a living instrument. And why it is a living instrument? Putting aside all the academic debate about the legal techniques that we can have, but clearly UNCLOS is a living instrument because it has what Mr. Murdoch also said about the rules of reference. We can import other rules from other agreements, the standards, the rules adopted by international competent organizations, into, to elaborate on the provision of UNCLOS. And in doing so, UNCLOS can be adaptable to the changes. And we do not need to revise or to amend UNCLOS because it's flexible enough. We do have enough mechanism to keep it updated. I want to add two further points about the relevance of UNCLOS. The first is about the state parties meetings. Putting aside what is the role, the function, and the authority of the state parties. But it's clear that the state party can make decisions which effectively amend certain provisions, be it administrative or not, of the UNCLOS. We can, recall the decision back in 2001 about the starting point for the submission of the coastal states relating to the outer limits of the continental shelf. The decision effectively put the starting point like 6 years later than the entry into force of the convention. 5 years, actually. Instead of 1994, we now have a 1999 as the starting point for the counting of the 10-year period for the submission of the limits of the continental shelf. And another point is I think that it is about the role of ILOs in developing or elaborating the different provisions of UNCLOS. Clearly, UNCLOS is a treaty negotiated under consensus procedure, and it contains a lot of compromises. And clearly, we do not have enough knowledge at that time for some of the issues that are facing us. I understand that climate change is not on the back of our mind when we negotiated the Law of the Sea Convention. But UNCLOS have a certain provision, certain concepts which are open enough and broad enough for us to deal with those issues. And the advisory opinion clearly deal with that one. It clearly acknowledged anthropogenic greenhouse gas emission can result in pollution to the marine environment. And it also take into account different rules under the United Nations Framework Convention on Climate Change, the Paris Agreement, to elucidate on the obligation of states, particularly dual diligence obligation. So I just want to conclude by offer some observations. I think that I completely agree with all the previous speakers that UNCLOS provide a stable framework that we can rely on, and we do not need to rely on other arguments. We do not need to create new zones for the oceans. It is already divided. And I think that the second point is that we have enough mechanism, enough techniques to update UNCLOS to deal with the new issue that we can have. And it is amazing that states refrain from using the former amendment procedure of UNCLOS. And there's argument that states will never use those procedures to amend UNCLOS. And the positive so far is the record so far is very positive. And I think that, but we should not rest on laurel. We still have some other, issue to really make UNCLOS at a stable legal framework that provide clarity to the legal order in the oceans. We have now 170 states parties to UNCLOS, but this number does not include some major maritime powers. Clearly, the US should be a party to that one. And also I echo the view by Dr. Taufan about the need to implement UNCLOS in a faithful manner, or effective implementation as you call it. I think that the excessive claims need to be rolled back. The implausible argument should be dropped about the rise, about the maritime zones. And finally, the past 2 days we have a talk about the COC, and it is important to remind that COC is negotiated within the legal framework provided by UNCLOS. And with that, I just want to thank you for your attention.
Sinkamon, DG Tang. I think we've heard 4 very different presentations, but with a striking degree of consensus on the key principles. We now have exactly 10 minutes for Q&A, and I would urge all the questioners, please, to keep your question to 2 sentences only. Okay, sir, Mr. Kui.
Thank you very much. My question to the panelists and also to the judge, Horinochi, if I may. The question is that any point in the evolution of UNCLOS relating to artificial feature or not? Thank you.
Thank you. Nice and short. I'll take 2 more questions and then I will turn to the panel. Yes, the youth spokesperson from Malaysia.
Hi, thank you. My name is Salisa. I'm a part of the Young Leaders Program. I would like to ask, considering there are many successes of UNCLOS, but one thing that it has not covered is the directions towards grey zone tactics. How can it supplement our mechanism on that? Thank you.
Terima kasih. And yes, the lady in the second row on my left.
I have a question that we all agree that UNCLOS will be evolving to facing the new problems and challenges. And my question would be, is there any limits for its living? I think the question relates to the relation between the UNCLOS and external rules. When we using external rules to make interpretation of UNCLOS, is there any limits or other rules to drive it in the right way to involving? Thank you.
Okay, thank you. That question is about interpretation of UNCLOS using external rules. Okay, so that's the first round of questions. Thank you. Which speaker would like to address any of those questions first? Andrew, please.
What was the first question?
Quinn, quickly just repeat your question, just quickly, sorry. We've forgotten it.
Any point in the evolution of UNCLOS relating to artificial feature?
Okay, so artificial features, grey zone tactics, and interpretation.
Okay, I'm going to have a go at all those, maybe in reverse order. I think that the convention does provide, so I don't have a copy before me, but for those who are required to interpret it, there is the ability to resort to general rules of international law in terms of the interpretation. So we saw, for example, in the South China Seas case, the ability to look at the obligations of flag states, bring in, for example, the collision regulations, for example, what the actual standards were for the conduct of Chinese vessels. There was also a view taken of whether those ships were attributable to the Chinese state, and therefore those are, again, rules of general international law and attribution. I think there is a whole panel on grey zone tactics. But I think if you're looking at that in terms of the identification of particular actors, I would look first and foremost at the rules of state responsibility. And if they aren't state organs necessarily, then you would look at whether they are, for example, under the instruction, direction, or effective control of a state, such that their actions are attributable to a state as a matter of international law anyway. So you can bring in other rules of international law, and I think those anyone who role it is in terms of applying the convention rules would be able to do that pretty readily. In terms of artificial features, I mean, we do have some provisions on artificial islands in terms of their creation and jurisdiction of the coastal states. There's also jurisprudence, as we know, that islands and rocks are naturally formed features. So, you know, if you're looking at kind of land reclamation or maritime reclamation activities, that can't change the legal status of the features themselves, and the jurisdiction would obviously be for the coastal state in terms of whether the permissions would be applied. And of course, you'd also have the environmental protections into the conduct of, if you are doing artificial features, how that is being done, and whether the rules of on preservation and protection of the marine environment are being applied. So I think you can bring these different rules in for those types of activities. Thanks.
Yes, Doctor.
Okay, I'd like to respond to the first question by Ambassador Kui. So about the artificial structure, I believe UNCLOS basically provide provision, for instance, on the Article 60, 80, and other in Part 12. So what I understand about this, where we take a look at the UNCLOS, artificial construction or structure will have very limited and very different to other features, especially the nature islands. So in the Article 60, it govern in the context of EZ, and the Article 80 will fall under context of continental shelf. Last but not least, under the Part 12, it also mentioned where the pollution, if I'm not mistaken, in the sense of dumping, for instance, from the artificial island, then the coastal state have a clear jurisdiction toward that incident or event. And then as for the question on the external rules or norms or framework, where I believe UNCLOS also provide somewhere in the later provision where there is a clear relationship between UNCLOS and other instrument where the link will be supportive each other. So the states cannot implement or apply, especially in the environment issue, less than what UNCLOS said. So I think this is the general relation between the UNCLOS and other instrument. And for the question on the, I believe about the peace and tactics, or also related to the Paris Agreement, where basically the issue of climate change is, we see that this issue not considered yet during the negotiation or the conference, the third conference on the law of the sea. But of course, UNCLOS provide very basic principles where very relevant to the issue of the climate change. What I'd like to say is when we address the climate change and its nexus with the ocean issue, then we need to also consider and take into account what UNCLOS already rules. Thank you.
Thank you. DG Dang, I'll invite you to say a few words quickly, and then Takai-san also very brief if you can.
Thank you. I just want to say that I completely agree with Mr. Murdoch about the gray zone tactic. I think that we have enough rules to deal with R1 But as a lawyer, we always need to have a specific case to analyze the rules that we can do. On the other hand, if you are interested in the gray zone tactics, you may want to read a new article about the gray zone warfare, about that in the the legal discussion we have the discussion about which rule apply and whether it is the gray zone or it is not covered by the particular agreement or not, or whether we need to rely on other legal instruments to that. I think that as lawyers we always need to have a very specific case and to see all the facts then before making any recommendation. And about the question about the rules of reference, I think that as my colleague from Indonesia already said, that UNCLOS have a certain provisions referring to the standards or rules adopted by competent international organizations. But I think that we also have the rule of interpretation, and it is very clear from the advisory opinion that we can import other rules into UNCLOS in order to elucidate the scope of obligation of the safe parties to the law of the sea convention. And it's very interesting that UNCLOS said that in that case that climate change law does not constitute lex specialis. So it's not something that that can override the obligation of state under law of the sea convention. Thank you.
Dr. Takai, quickly if you would.
Sure. Thank you very much. Previous speakers have already alluded to very comprehensively the issues raised by the question, so I will not add that much, but I just wanted to say on the issue of artificial features, or perhaps a distinction should be made between, well, first of all, those relating to artificial islands and those which were naturally formed. And with regard to the maritime features naturally formed, you would be able to strengthen the features through artificial works, but you cannot change the legal status of the feature by simply adding artificial works. Thanks.
Dr. Takai, thank you very much. For the next round of questions, because we have such a high degree of consensus here, I'm not going to ask people to ask a question and have every speaker answer it. I'm going to invite the questioners to ask a question and direct it to one speaker, if that's okay. And I'm going to start with a question online, and it's for you, Dr. Takai. How does Japan view the impacts of China's straight baseline claims in the Gulf of Tonkin on regional maritime stability and security?
Oh, thank you. Okay, so let me just digest the question very quickly. Okay, so, well, first of all, I'm not speaking on behalf of the government, which is obvious, but I thought perhaps it's very important for states to agree in a mutually agree on their maritime boundary issues, but I think it's important for all states, especially when it comes to the extent of maritime zones. So I think in that sense, it is not the issue limited to the coastal the neighboring states, but I think the implications could be broader, well, involving other states as well. I don't know if that answers the question that well,
Okay,
but
that's your answer. That's fine. Okay, questions. Very enthusiastic gentleman at the far side.
Right. So for Andrew, what do you think about the last-minute clause that was inserted into?
Sorry, to whom are you addressing the question?
For Andrew, for Mr. Murdoch. What do you think about the last-minute clause that were insisted on into the BBNJ by China that could potentially limit the creations of MPA in some of the areas where high sea is supposed to exist, including Antarctica or maybe the South China Sea? And for the other three, do you think by considering UNCLOS as the constitution of the oceans automatically limit the opportunity to explore other alternative that could be a little bit more radical? Thanks.
Okay, thank you. I think that second question has been well addressed already, but Andrew, you've got the first one. I'll take two more and then we'll get the answers. Okay, the lady in the fourth row with the glasses. Yes.
Thank you so much. So my question is for my Indonesian speaker there, actually my senior. So Dr. Muhammad Taufan, so what is the strategy of Indonesian foreign policy to facilitate and govern environmental-driven actions proposed in addressing a South China Sea dispute in the 21st century? Thank you.
Okay, and a third questioner, hands please. Yes, the lady in the third row, second from the edge. I'll pretend I don't know who you are.
Thank you. My question is for Mr. Murdoch. But do you think an implementation agreement is required for submarine cables under UNCLOS? Are new rules required?
Are new rules required under UNCLOS for submarine cables? Okay, thank you. Those are the three questions. Andrew, you've got two questions. Are you happy to do those before I pass to Dr. Taufan?
Thanks. Good questions. So with BBNJ, I think you have to remember, I mean, the feeling in the room was that if this wasn't done in that session, it wasn't going to happen for some considerable time, and that it was only going to be done if you were going to get consensus. And so there are certainly some provisions in the BBNJ agreement which are not necessarily ideal, and in terms of the ambition that some states would have in terms of some of the scope of the provisions, but sometimes the consequence of that is to get consensus amongst states. And when states, in all international treaties, that's just how it goes. And I think with BBNJ, the benefits of what's in there far outweigh some of the limitations and some of the clauses that were negotiated from some states' perspectives. And there were it wasn't just China that you mentioned in your question. There were other states who had particular interests in certain areas of BBNJ that they fought very hard for. In terms of the Antarctic system, I would say the Antarctic treaty system is out with in terms of the competence of BBNJ. In terms of the new rules around submarine cables, and I think it did touch on the presentation, I think there's a really interesting case for that. One of the problems is there is some pretty old law on some of the cables, and these are now critical national infrastructure, and states are potentially going down a route of how do you protect these, because if it's kind of damaged or the like, there's a kind of remedy. Outside of that, if it's abused or intentionally damaged, what do? Can you use force? Can you use countermeasures? And all those arguments are being looked at. It would be far better, at least, to have a peaceable regime to deal with the responsibility of states, and that might be something I think the trend is going, because these things are so important. I think it's going to need new law, though, because it's not really an interpretive approach on some of this. I think states will be able to respond with existing laws, but if you want a better regulatory regime, I think it's going to need new provisions. Thanks.
Thank you. Pak Muhammad.
Thank you, Ambassador. So, as for the question with respect to this South China Sea and what would be the Indonesian strategy, so let me approach with 3 points. First, Indonesia's position is very clear, as I mentioned, that Indonesia is not a claimant state toward the maritime future in the South China Sea, the future itself, but we bordering with the South China Sea, as well as we not bound by any claims made in contravention to international law, including UNCLOS. That's very clear what we stated through the diplomatic note to the UN Secretary General back in 2020 and 2010. The second point is about the COC negotiation process. Yesterday we discussed thoroughly about this. So we support and committed to the negotiation of this COC. We believe the COC negotiation process itself not only the aim or the target to achieve the substantive rules, for instance, but the process itself for us is valuable to build the trust among the parties, the MS as well as the China. But of course, we really expect the significant progress in the near future. The third one, Indonesia, since 1980, together with other ASEAN countries, have the workshop, avenue or mechanism where we discuss various issues pertaining to the South China Sea, for instance, on the marine environment and other related issues. We believe that these 3 points at least part of our strategy, and we keen to expand and deepen other strategy on this. And if I may, I believe. I think that's the question. One point on the implementing agreements on or new rules for the submarine cables. I just want to say 2 points about the mechanism. Perhaps indirectly address that issue, but don't forget that we have at least 2 mechanisms. First, if there is any idea or suggestion or proposal from the states or the ICPC, for instance, that's open for the states to discuss that. And the second one, in the UN itself, we believe we have mechanism of informal consultative state parties, where states can identify the emerging issues to be followed up through the UN mechanism. Thank you.
Thank you. Okay, this is the third and last round of questions. Remember, short question, and please direct it to your preferred answerer. Okay, yes. The gentleman next to the lady from Indonesia, and then the woman at the very back with her waving her hand. Yep, that one. And the third one, who's the lucky third? The gentleman in the blue shirt. Okay, who has the microphone? Those 3 people who I nominate, please put your hands up so the staff can find you with the microphone.
Can you hear me?
Oh, yeah. Okay, go ahead.
Can you hear me? Can you hear me? Can you hear me?
Little bit. You have to speak more loudly. The microphone is on, but you have to speak loudly.
Can you hear me?
Yes.
Okay. I'm from EC Study, Diplomatic Academy of Vietnam, and I have two questions. The first question to Dr. Nguyen Đăng Thắng.
Just one question, please.
One question. How could ITLOS establish a comprehensive and consistent approach to determine which other treaty norms could be relevant to the interpretation of UNCLOS? Thank you.
And so to whom was that addressed? Okay, can you repeat the question, please, a little bit more loudly?
Okay. My question to Dr. Nguyen Đăng Thắng, how could ITLOS establish a comprehensive and consistent approach to determine which other treaty norms could be relevant to the interpretation of UNCLOS?
Okay, we got it. Next question, please. Could the two other questioners that I nominate, yes, there's the gentleman in the blue shirt just here, and the gentleman in the black jacket. Okay, thank you.
Okay, thank you. So I'm Hoàng Anh, I'm from the Young Leaders. I want to address Dr. Thắng. To what extent can autonomous unmanned vehicles be defined as warships? And how can we define intent if decisions are made by an automated algorithm? Thank you.
Sorry, to whom are you addressing the question?
Dr. Nguyen Đăng Thắng.
Dr. Tang again. And can you repeat the question a little bit more loudly?
Okay. My question is, to what extent can automated unmanned vehicles be defined as warships? And how can we define intent if it's decided by an algorithm? Thank you.
Okay, thank you. And the third questioner is the gentleman in the blue shirt, that's it. Yep, okay, please. Tell me clearly who you're asking, and please ask your question clearly.
Yeah, I want to address my question to Mr. Andrew Murdoch. And my question is about the overlapping jurisdictional claims. And my question is that how has the UN clause influenced the resolution of overlapping jurisdictional claims in the South China Sea? And what are the prospects for a more definitive resolution to solve the overlapping jurisdictional claims in the future? Thank you.
Okay, so Tang, shall I get you to go first because you've got two?
Thank you very much, and thank you for the question. I think that the first one, again, it is very, case specific, but I think that what the judges at ITLOS can do and what they have always been doing is that to make use of Article 131 of the Vienna Convention on the Law of Treaties about that is a rule of interpretation. And when relying on that rule, when utilizing that rule, single rule of interpretation, they always can take into account the subsequent agreement or subsequent practice of states. And in doing so, they can, have a very, consistent approach to refer to the other rules and regulations under other treaties. About the question of, I think that the second question is about the autonomous vehicle and its relation to worship. To answer that question, I may need to rewrite another dissertation. But the short answer is that it can be related, but it can also be not related. And again, it's very much depends on what you define as the autonomous vehicle, whether it is in the loop, on the loop, or out of the loop. And because you know that when you define the worship under Law of the Sea Convention, there's 7 elements that autonomous vehicle can, satisfy, but also there are the elements that it may not satisfy if it is out of the loop. We're talking about the crew, about the, whether it's a ship, whether it is under the command of a person, etc. So it is very much a context specific, and it is very much depend on what kind of autonomous vehicle that you are talking about.
Thank you. Mr. Murdoch, you have the last answer for this panel.
Great, thanks for the privilege. Yeah, so, I mean, overlapping claims, as we know, are incredibly common. I mean, not just the South China Seas in terms of claims between opposite or adjacent states. So there's nothing necessarily new about the South China Seas setting. And the convention, to an extent, provides some frameworks in terms of those states with those claims with a continental shelf or otherwise, in terms of reaching into some form of provisional arrangements without jeopardizing or hampering the kind of reaching of an agreement. But as we've seen mostly these things are settled by way of negotiation. And if it can't be settled by negotiation, then resort can be had, and often I think is the way to get through this, through to compulsory dispute settlement mechanisms to actually find the way through. Of course, that politically takes some bravery to settle that, because as we've seen in other areas, states will sometimes see this, if they don't get the maximum extent of their claims, will see this as some form of loss of sovereignty, as if they're losing sovereignty or sovereign rights or a jurisdiction. Whereas in reality, for externally, these are rights and claims that they weren't entitled to in the first place. So it's never a loss, it's more an adjudication. So I think there is a framework there. The reality on most areas, it's only going to be settled eventually through negotiations or availing themselves of some dispute settlement provisions. Thanks.
Thank you for those excellent questions. I apologize to those who I didn't get to, including online, but I hope you can all join me in thanking this terrific panel for a very interesting discussion. Thank you, everyone. I think we all deserve a coffee break.
Well, thank you, His Excellency, and thank you, our speakers. Before we go to the coffee break, can I have your attentions for about 1 minute? First of all, you could see the QR code here right on screen. Please use your mobile device to contribute your feedback on how we can improve our conference. And this is also an anonymous survey for your information. And your feedback, as always, is highly appreciated. So, Ambassadors, Andrew, your feedback about gender diversity and gender balance is very well taken. And